In this lecture, we shall be discussing separation of powers. Separation of powers and its applicability in Ghana. Now, in every government, we have governmental power being exercised. In every government, we have the legislative power, we also have executive power, and we have judicial power. Now, what the concept of separation of powers explains is that these powers of governance, i.e., the legislative power, the executive power, and the judicial power, they should be exercised by three different organs of government. In other words, the organ that exercises the legislative power should be different from the organ exercising executive power, and it should also be different from the organ exercising judicial power. In fact, the very people who argue for the very strict form of separation of powers even go to the extent of saying that no single person should even belong to more than one organ of government. In other words, if somebody is a parliamentarian, i.e. belonging to a member of the legislature, such a person should not be allowed to belong to the executive and should also not be allowed to belong to the judiciary. One would ask, why do we even think of having separation of powers? Why did this whole concept even develop? Now, it was realized that if the same person that is exercising the legislative power and making the laws is the same person who is going to interpret the law and is the same person who is going to implement the law, then that can lead to tyranny and abuse of power. That can lead to arbitrary use of power because the very people who are making the laws are the ones who are going to implement it in the way they so wish, and they will interpret it in the way they so want. And so, concentration of power into one organ or one person was viewed as something that could breed tyranny and would not guarantee the liberty of man. In fact, one very profound proponent of this theory, Baron de Montesquieu, in his book, The Spirit of the Laws, he even argued that without separation of powers, there would be no liberty. Without separation of powers, there would be no liberty. And it's not only Baron de Montesquieu who has shared that fear that if we have concentration of power in one person, there will be no liberty. In fact, as far as in the year 1789, the French Declaration of the Rights of Man in 1789, they went as far as to say as follows, and I quote, that any society in which the safeguarding of rights is not assured and the separation of powers is not established has no constitution. In fact, they have gone as far as even mentioning that if there's a society where there's no separation of powers, then they are saying then there's no constitution, because there's going to be arbitrary power. There's going to be tyranny. The people who are making laws will not even subject themselves to the laws that they are even making. It is for this reason that some scholars have indeed argued that separation of powers is the very essence of constitutionalism, and it's also a universal criterion of a constitutional government. Because if you have a constitutional government where we have concentration of power in one person, and the person is going to abuse people's human rights, then it means that you don't have any limits placed on the exercise of governmental power. So separation of powers developed mainly to achieve the purpose of preventing tyranny and abuse of power. One of the most profound statements about the justification of separation of powers is captured in the words of John Locke in his second treatise of civil government. John Locke, in the second treatise of civil government, he also made a profound statement about how it may be too dangerous to put the executive, legislative, and judicial power into the hands of one person. In fact, this is what John Locke says, and I'm quoting, that and because it may be too great a temptation to human frailty, apt to grasp at power, for the same persons who have the power of making laws to have also in their hands the power to execute them, whereby they may exempt themselves from obedience to the laws they make, and sue the law both in its making and execution to their own private advantage, and thereby come to have a distinct interest from the rest of the community, contrary to the end of the society and government. Quote ends. So John Locke is saying that it will be too dangerous, it may be too great a temptation to human frailty, that you will allow the very people who are making the laws to be the very people who are going to implement them. Because if you allow that, then the people who make the laws may even exempt themselves from obedience to the law they make. They will make the laws in such a way that they themselves will not even have to obey the laws. And then they will couch laws that would only be to their own private advantage, as distinct from the advantage of the rest of the community. And therefore he's saying that it is too dangerous to allow the power to go into one person's hands. A critical analysis of John Locke's exposition, you realize that his conception more or less was concerned more about the legislative and executive power. He gives less attention to the judiciary, because he only talks about too great a temptation to allow the very people making the laws to be the very people who would implement them. Little or nothing is said about the judiciary. So John Locke actually mentioned that it would be too great a temptation to allow the very people who are making the laws to be the very people who will be implementing them. Because if you allow that, they may make laws that they themselves would exempt themselves from obeying. Also, Baron de Montesquieu, in his book The Spirit of the Laws, he also took a very interesting position about separation of powers that has shaped the jurisprudence in that particular area of law. Montesquieu took the position that when the power is concentrated in the hands of one person, when the executive, legislative, and judicial power is concentrated in one person's hands, it may lead to despotism, and then it may lead to abuse of power. And therefore, Baron de Montesquieu, in his book The Spirit of the Laws, advocates that in order to secure the liberty of man, it is good that distinct people would be exercising legislative, executive, and judicial power. Now, one thing that must be recognized at this point, that while John Locke placed more emphasis in the second treatise of civil government, whereas John Locke placed more emphasis on just the legislature and the executive, Baron de Montesquieu recognized the role of the judiciary as an organ of government and having a separate function. And therefore, if you look again at the position of John Locke and Baron de Montesquieu, it will be realized that John Locke was more inclined towards separation of personnel, whereas Baron de Montesquieu was more inclined towards separation of institutions, because Baron de Montesquieu was arguing of institutions, different institutions exercising governmental power. So please, as far as the principle of the concept of separation of powers is concerned, there are some names you can never forget when you are laying down the theoretical basis of separation of powers. You cannot afford to forget the name of John Locke in his book, The Second Treatise of Civil Government. And you cannot afford to forget the name of Baron de Montesquieu in his book, The Spirit of the Laws. And you know that if you aggregate their views, they are all expressing the fear that if power, executive, legislative, and judicial power are concentrated in the hands of one person, it may lead to despotism, abuse of power, which would yield and lead to the abuse of people's rights. Having laid down the theoretical basis of separation of powers, the next part of our discussion, we shall focus on how the concept of separation of powers has been applied in the case law. But we shall first begin with how the concept has been applied in foreign jurisdictions. And when I say foreign jurisdictions, I mean decisions of the courts that are not in Ghana. So we refer to decisions in the United Kingdom, we refer to the decisions in the United States, before we come to decisions in the Republic of Ghana. So we shall begin with decisions in the United Kingdom and see how the concept of separation of powers has manifested in the case law. The first case we shall begin with is the case of Blackburn versus Attorney General. 1971 Two All England Reports, page 1318. Blackburn and Attorney General is a profound decision of the courts in the UK and how they have manifested the principle, the concept of separation of powers. In this case, Blackburn brought the action against the Attorney General, and the crux of his case was that he was challenging and taking a declaration to more or less prevent the Crown from signing the Treaty of Rome. He was trying to challenge the Crown signing of the Treaty of Rome. And over here, his argument was that if Her Majesty's government proceeds to sign the Treaty of Rome, then that would amount to surrendering in part the sovereignty of the Crown in Parliament and surrendering it forever. So Blackburn was saying that then the Crown should not be allowed to go ahead and sign the treaty. And that is what, in effect, he was challenging. Lord Denning was one of the judges in this case, and he had to decide on whether the court had the power to prevent the Crown from signing a particular treaty. This is what Lord Denning had to say, and I quote: "The treaty-making power of this country rests not in the courts, but in the Crown. That is Her Majesty, acting on the advice of her ministers. When her ministers negotiate and sign a treaty, even a treaty of such paramount importance as this proposed one, they act on behalf of the country as a whole. They exercise the prerogative of the Crown. Their action in so doing cannot be challenged or questioned in these courts." The quote ends. So in effect, Lord Denning was saying that the treaty-making power rests in the Crown, but not in the courts. Now you will not see Lord Denning mention expressly separation of powers, but if he is recognizing that the power to enter into treaties is a preserve of the Crown, and therefore the courts will not poke their nose into it, he's recognizing the limits of the courts and recognizing that they are not supposed to be extending their tentacles into areas and arenas that their power does not allow them to. Another judge in the case, Salmon LG, also mentioned and indicated that The courts do not have any power to interfere with the treaty-making power of the sovereign. And this is what Simon LG says, I'm quoting, that while I recognize the undoubted sincerity of Mr. Blackburn's views, I depreciate litigation, the purpose of which is to influence political decisions. Such decisions have nothing to do with these courts. These courts are concerned only with the effects of such decisions, if and when they have been implemented by legislation. Nor have the courts any power to interfere with the treaty-making power of the sovereign. As to Parliament, in the present state of the law, it can enact, amend, and repeal any legislation it pleases. The sole power of the courts is to decide and enforce what is the law and not what it should be now or in the future. And the quote ends. So you realize that Simon LJ clearly made the point that the sole power of the courts is to decide and enforce what the law is and not what it should be now or in the future. So you realize that embedded in the dictum of the judges is that they are all trying to restrain themselves and the judiciary from extending their tentacles into the avenue and arena of another organ of government. This is the case of Blackburn and Attorney General. Now we can move and take a look at the situation in the USA. And we shall begin with the case of Youngstown Sheet and Tube versus Sawyer. Youngstown Sheet and Tube versus Sawyer, which has now come to be popularly known as the Steel Seizure case. The Steel Seizure case. Now this case is very important in view of the judgment that was read by Justice Jackson and Justice Black. In the same case, Justice Jackson and Justice Black made statements about separation of powers, which are very crucial and will aid you in understanding the concept of separation of powers. Justice Black's dictum in this case is one that leans more in favor of the classical form of separation of powers, the very strict form of separation of powers, the one that operates in the watertight compartments. That is the position taken by Justice Black. And this is what Justice Black said in the Steel Seizure case, and I quote, "The founders of this nation entrusted the lawmaking power into the Congress alone in both good and bad times." Then the quote ends. Justice Black's approach is what has come to be known as the doctrinaire approach. It provides that no matter what happens, if the law says that we should be separate in terms of functions, we should remain as such to be separate, both in good and bad times. There should be no interference whatsoever by any organ of government. That is the very strict form of separation of powers, as we see in the Steel Seizure case, the case of Youngstown Sheet and Tube versus Sawyer, per Justice Black. The very strict form of separation of powers. And then we have the less doctrinaire approach, the approach that allows the participation of other branches in another branch's functions. The approach that recognizes that when the organs of government work strictly separate, it may make the government unworkable. The approach that contemplates that one organ can depend on the other. That is the approach that was espoused by Justice Jackson in the same case of Youngstown Sheet and Tube versus Sawyer. And this is what Justice Jackson says, and I quote: while the Constitution diffuses power to better, I'll take it again. While the Constitution diffuses power, the better, to secure liberty, it also contemplates that practice would integrate the dispersed powers into a workable government. It enjoins upon its branches separatedness, but interdependence, autonomy, but reciprocity. In view of how very accepted the view of Justice Jackson has come, I shall take it once again. While the Constitution diffuses power to secure better liberty, it also contemplates that practice will integrate the dispersed powers into a workable government. It enjoins upon its branches separateness but interdependence, autonomy but reciprocity. Now, having dealt with the dictum of Justice Jackson, it is important to mention that the position taken by Justice Jackson is one that reflects the essence and substance of the concept of separation of powers in theory and practice, especially in contemporary times. This is because applying the strict form of separation of powers, which requires the organs of government to be very, very separate without any interference whatsoever by any of the other organs of government, can actually result in the government being unworkable. There must, in practicality, be some interdependence of some sort. How would it be possible if we go by Justice Black's position that so long as the power to make laws is given to the legislature, then there should be no interference whatsoever from any other organ of government? There should be some check, at least, by the executive. That is why Justice Jackson mentions that even though the Constitution contemplates separateness, it also contemplates interdependence. They must depend on each other. So, for example, in Ghana, you realize that it is the parliament that has been given power to make laws. But whenever they make the laws have to be approved and assented by the executive before it becomes law. So the executive also cannot make the law on its own. It must wait for parliament to pass the bill. So you can see that in practicality, they are depending on each other. So the dictum of Justice Jackson, when he mentions that even though the Constitution diffuses power, the better to secure liberty, it also contemplates that practice will integrate the dispersed powers into a workable government. When Justice Jackson says that it enjoins upon its branches separateness but interdependence, autonomy but reciprocity, it appears his position is what rather reflects the applicability in contemporary times. Having said so, let us delve into the Ghanaian legal jurisprudence and find out how the concept of separation of powers has been applied within the Ghanaian legal landscape. We shall begin with the case of Tufor and Attorney General. Now, in Tufor and Attorney General, an action was brought by a private citizen against the Attorney General, seeking for a declaration entirely that Chief Justice Apalu was still the Chief Justice of the Republic of Ghana, and that he ought not to have gone to Parliament for any form of approval. Now, the action was brought against the Attorney General as first defendant and the Speaker of Parliament as second defendant. The Speaker of Parliament was added because it is a Speaker who superintended over the vetting of Chief Justice Apalu in Parliament. So he was added as a proper party to the suit. But the Attorney General raised an objection. And the essence of the objection was that the Speaker of Parliament ought not to be joined as a party to the suit, and that he was not a proper party to the suit. The court indeed recognized that the Speaker of Parliament was not a proper party, and the court ordered the Speaker of Parliament to be struck out as a party. But what is interesting to note is the reason the court gave for striking out the Speaker of Parliament as a party. SOA JSC at page 650 of the report stated as follows, and I quote, "And therefore the courts take judicial notice of what has happened in Parliament. The courts do not and cannot inquire into how Parliament went about its business. These constitute the state of affairs as between the legislature and the judiciary, which have been crystallized in Articles 96, 97, 98, 99, 103, and 104 of the Constitution. Of particular importance to us are the provisions of Article 96 of the Constitution. They confer on Parliament freedom of speech, of debate, and of proceedings in Parliament. The article also states categorically that freedom shall not be impeached or questioned in any court or place out of Parliament. The courts cannot therefore inquire into the legality or illegality of what happened in Parliament. Insofar as Parliament has acted by virtue of the powers conferred upon it by the provisions of Article 91(1), its actions within Parliament are a closed book." Quote ends. Even though SOA GSA did not mention expressly separation of powers, underlining this dictum is a clear expression that the courts are restraining themselves from interfering in the affairs of Parliament. That is why SOA GSA says the courts cannot therefore inquire into the legality or illegality of what happened in Parliament, insofar as Parliament has acted by virtue of the powers conferred upon it by the provisions of Article 91 clause 1. Its actions within Parliament are a closed book. It's affirming how the courts and the judiciary refrain from interfering in the affairs of the Parliament. So Tufor and Attorney General can be used to explain how the concept of separation of powers has been recognized and applied in Ghana. Another case we can look at in Ghana that has affirmed the applicability of separation of powers is the case of Ghana Bar Association versus Attorney General in another. 1995-96, One Ghana Law Report at page 598. Now, the facts which culminated in this case are that the president of Ghana appointed one Justice I.K. Aban. He nominated Justice I.K. Aban, a justice of the Supreme Court, for appointment as Chief Justice after due consultation with the Council of State. The nomination was approved by Parliament. Then the plaintiff, the Ghana Bar Association in this case, brought an action to the Supreme Court claiming that appointment of I.K. Aban as Chief Justice, they were claiming that it was an appointment which was contrary to Article 128 Clause 4 of the Constitution. According to the plaintiff, Justice I.K. Aban was not a person of high moral character and proven integrity, and therefore such a person could not be qualified for appointments as a justice of the Supreme Court. So essentially, the action of the plaintiff was that even though the Justice I.K. Aban was already a justice of the Superior Court, the plaintiffs were saying that he being appointed to the Supreme Court as the Chief Justice, it was an act which was contrary to Article 1284 that requires that the Chief Justice must be a person of high moral character and proven integrity. The court noted that by the dictates of Article 144 Clause 1 of the Constitution, the appointment of the Chief Justice is one that had been specifically committed to the legislature and the executive. The executive appoints, then the legislature approves. However, since the power to appoint the Chief Justice is the prerogative of the executive under Article 144 Clause 1, any attempt by the courts to declare the null and void any such appointment would amount to removal of such a person from office. Meanwhile, the power to appoint is rather that has been reserved for the executive. And there is a laid down procedure for removal of a Chief Justice under Article 146. But the plaintiff did not go ahead to trigger the removal procedure under Article 146. They rather brought an action claiming to be enforcing Article 128 Clause 4 and arguing that the appointment was not valid. The Supreme Court noted that the power to appoint the Chief Justice was the prerogative of the executive. And when they have done so in consultation with the requisite institutions, an appointment is deemed to be valid. The court cannot usurp the constitutional function of the executive. And therefore, if anything at all and the plaintiff wants to remove I.K. Aban from office, then he should rather go and then trigger the provisions under Article 146. What is more interesting to note about this case is that I.K. Aban in this case was already even a justice of the Superior Court. And so if the court should have gone ahead to hold that he's not a person of proven integrity, it means that he's even going to lose his position as a Superior Court judge. And that is why the court mentioned that such a procedure for the removal has been specifically provided for, and they could not be usurping the powers of the executive. It means that in between the lines, you can see that Ghana Bar Association and Attorney General, they were still having some undertones of separation of powers, where the courts were refusing to, declining the invitation to remove a person that has been properly appointed by the president as the Chief Justice. The court declined the invitation. But one thing that we must point out is that separation of powers is just a concept and it is not a doctrine. It is just a concept. We have seen two cases so far in Ghana that the concept has been applied in. To for an Attorney General and then Ghana Bar Association versus Attorney General. We also have to look at the case of MPP versus Attorney General 31st December case. MPP versus Attorney General 31st December case. Now, the essential facts of this case are that the president was taking steps to declare 31st December as a national holiday to be celebrated with state funds. An action was brought by the MPP arguing that such an intended celebration was in conflict with the 1992 Constitution and therefore illegal. One argument that was raised by the Attorney General was that the power to declare which days are holidays is the prerogative of the executive. And the court should recognize that prerogative and not decide for the executive which days are supposed to be holidays and which days are not supposed to be holidays. They were calling for separation of powers. The court noted that principle of political question, which is the nature of separation of powers, such a concept must always bow to the supremacy of the 1992 Constitution. And therefore, when it appears that the applicability of the concept is going to be in conflict with the Constitution, then the court indeed have the power to disregard that interpretation and rather affirm the supremacy of the 1992 Constitution. It means that the separation of powers concept, it is a concept that will be applied if it is desirable. But if it is clear that its application is going to be in conflict with the Constitution, then that's one. They will rather affirm the supremacy of the Constitution and then violate that concept of separation of powers. It means that separation of powers is a concept, and in Ghana, it is going to be applied only if its applicability is going to be in consonance with the Constitution. And therefore, people who hold a view that separation of powers is a doctrine have to revise that stance. It is just a concept that will apply when it is convenient to do so. This same point was made in the case of Asai versus Attorney General. That's related to the Speaker of Parliament. This is what Kluje, JSU, had to say about the concept of separation of powers. And I quote, "The plaintiff makes a further philosophical attack on the provision for the performance of his functions when the president is incapable of performing those functions. The criticism is particularly directed at Article 60, Clause 11 of the Constitution, which provides that the Speaker of Parliament shall perform the functions of the President when both the President and the Vice President are unable to perform them. He says that allowing the Speaker of Parliament to ever perform the functions of the President is objectionable because it violates the doctrine of separation of powers. For this purpose, it does not seem to matter whether the incapacity arises from physical or mental infirmity, or from the fact of absence from Ghana. The criticism is that whatever the reason, the Speaker of Parliament, being the head of the legislative branch of government, should never act for the President, who is the head of the executive branch. Then he goes ahead. The doctrine of separation of powers is a philosophical and political dissertation which seeks to compartmentalize the organs of government into three distinct branches denominated as the executive, the legislative, and judicial branches. The doctrine proceeds to postulate the theory that for efficient governance, and in particular to avoid despotism and tyranny, the three branches of government must remain distinct. For the concentration of power in the hands of one person or one set of persons has the natural tendency to breach despotism and tyrannical rule because of the fallibility of man. It is important at this point to set the facts in a very good perspective to let everybody understand the facts that culminated in this case. The crux of the plaintiff's argument is that when the president and the vice president travel out of the country, the Speaker of Parliament should not be sworn in as the occupant of the executive power, because swearing in the Speaker of Parliament would violate separation of powers. Now, I'll proceed to read what Kluge said, and I quote, "The plaintiff does not directly make an issue of who should perform the functions of the president when the president, the vice president, and the Speaker of Parliament are all unable to perform the functions of the president, as stated in Article 60, Clause 11. However, because of the interpretation he invites us to place on Article 60, Clause 11, and his appeal to the doctrine of separation of powers, he must also be taken to imply that it would be unconstitutional for the Chief Justice to perform the functions of the President temporarily when all the other three are unable to perform them. If that is the implication of the arguments before us, I would like to categorically reject such a proposition." And this is where we get to the main meat of separation of powers. I'm still quoting. "Rather than rely on the doctrine of separation of powers in the construction of our Constitution, I would draw upon a philosophical and principled theme that appears to me to animate the constitutional structure that we have adopted. That basic assumption is that the executive power of the presidency should never be in abeyance. To have such a situation when there is no person in Ghana to exercise the executive power of the presidency would be a prescription for chaos and anarchy, and could expose this nation to both internal and external instability." And this is where I'm coming to the main aspect of the separation of powers. So I'm quoting again. And this is the dictum of Kluge, GSC. So I'm quoting. "If the doctrine of separation of powers must be violated to ensure that the office of the president is never to be unperformed and never in abeyance, I would readily violate it to spare the nation anarchy and chaos. Nowhere in the Constitution are we enjoined to observe or apply such a doctrine." I'll read that portion 5 times. Nowhere in the Constitution are we enjoined to observe or apply such a doctrine. Nowhere in the Constitution are we enjoined to observe or apply such a doctrine. Nowhere in the Constitution are we enjoined to observe or apply such a doctrine. And the doctrine being referred to over here is separation of powers. It is a goal that may be attained if desirable. However, if the need arises, the doctrine must yield to pragmatism and political reality. Nowhere in the Constitution are we enjoined to observe or apply such a doctrine. It is a goal that may be attained if desirable. However, if the need arises, the doctrine must yield to pragmatism and political reality. Therefore, relying on other parts of the Constitution and its principled structure, it is clear that the Constitution envisages that, if need be, the Chief Justice, the head of the judicial branch, may perform the functions of the President on a temporary basis. Such a need may arise if, God forbid, the President, the Vice President, and the Speaker of Parliament are all, because of a national emergency or national disaster, unable to perform the functions of the President. What I want to draw your attention to with this case is that this case clearly affirms that separation of powers is not a concept or is not a doctrine that we can apply hook, line, and sinker in Ghana. It's not as if the moment we say separation of powers, then we are going to apply it. We have been told by Kluge, GSC, that nowhere in our Constitution are we enjoined to practice such a doctrine. It is a goal that may be attained if desirable. But if its application is going to be a conflict with the Constitution, we shall violate it. Just the same way that we violated it in the case of MPP and Attorney General 31st December case, we shall violate the principle of separation of powers if its violation must be done in order to ensure conformity with the 1992 Constitution, which is the supreme law of the land. Now, having said so, it means that we have dealt with how the concept of separation of powers applies in the UK. We dealt with Blackburn and Attorney General. We've seen the US case of Youngstown Tube and Company versus Sawyer. We've seen how the doctrine was applied in Ghana. We saw how it animated the decision in Tufo and Attorney General, where they said whatever happens in Parliament is a closed book. We've seen how it also animated the decision in Ghana Bar Association and Attorney General. And then we've also seen that in Ghana, even though we recognize separation of powers, we don't apply it hook, line, and sinker. We realize that in MPP and Attorney General 31st December case, the court affirmed the supremacy of the Constitution and sacrificed separation of powers. And in Asari and Attorney General, we have been told that nowhere in our Constitution are we enjoined to practice such a doctrine, and that we can attain it if it is desirable and it is in conformity with the Constitution. But if its applicability is going to breach the Constitution, then we will rather violate that doctrine or concept of separation of powers. And so, if the question is asked, what do we practice in Ghana then? We hear the scholars saying that in Ghana, we practice separation of powers and we practice checks and balances. We practice the situation that is more workable, the one that was contemplated by Justice Jackson in the Still Seizure case, that there must be interdependence among the organs of government. That is what is workable, and that is what we apply in Ghana. We do not apply that watertight separation of powers that was advocated for by Justice Black in the Still Seizure case. We rather align with the flexible aspects the one that goes with checks and balances, as was advocated for by Justice Jackson in the Still Caesar case. And so in Ghana, you will see that Article 58, 93, and 125 vest executive power in the president, vest legislative power in parliament, and vest judicial power in the judiciary, respectively. It means that in Ghana, we have given the powers of government to 3 different institutions, evidencing some extent separation of powers. But I must be quick to add that even though we have 3 different institutions that are supposed to exercise governmental power, there are enough provisions in the Constitution to demonstrate that we do not practice the strict form of separation of powers that Justice Black was advocating for in the Still Caesar case. There are sufficient provisions in our Constitution to demonstrate that there's interdependence among the organs of government. And so I can explain that first by starting with Article 71 of the Constitution. Under Article 71, it has been mentioned that the salaries and allowances payable to the Speaker of Parliament, the Deputy Speakers, and the Members of Parliament, and even the Chief Justice and other justices of the Superior Court, their salaries shall be determined by the President on the recommendations of a particular committee. It means that the executive has a role of checking legislature in determining their salaries. And in the same way, we see over here under Article 71, Clause 2, that the salaries and allowances payable to the president as well and his ministers, they shall be determined by Parliament. You see the check and balance over there. The executive is checking the Parliament is checking the executive. Again, under Article 78, even though the executive is given the power to appoint his ministers, when the executive appoints his ministers, he must gain the prior approval of Parliament. This is showing how Parliament and the legislative arm can operate as a check and a balance on executive power. Again, we have Article 106 that deals with the power of Parliament to make laws. We see over there that when Parliament passes the bill shall not come and become law until the President has passed his assent. It shows that the executive has a way of checking legislature. Again, under Article 75, when the President enters into a treaty, we must come and seek the ratification of Parliament. This is showing that even though it is the power of the executive to enter into treaties, he cannot operate in a watertight compartment. He must gain the prior approval of Parliament. Again, under Article 181, we've seen over there that when the President is entering into an international business transaction or a loan, he must gain the prior approval of Parliament. Again, we've seen under Article 67 that the President shall, at the beginning of each session of Parliament and before a dissolution of Parliament, he shall deliver to Parliament a message on the state of the nation. This is showing how Parliament can also check the President. So at the end of the day, you realize that in Ghana, we don't have the strict form of separation of powers. We see one organ checking the other time in, time out. Meaning that what Justice Jackson said in the Still Caesar case that we don't have, even though the constitution contemplates independence, it also contemplates interdependence. It means that what we practice in Ghana is not the strict form of separation of powers. But remember at all times that in Ghana, nowhere in our constitution are we enjoined to practice separation of powers. As Kluge told us in Asari and Attorney General, it is a goal that may be attained if it is desirable. But if its application is going to yield to a conflict of the constitution, we shall be ready to violate that concept and rather affirm the supremacy of the constitution. So by way of recap, we have dealt with the definition of separation of powers according to the theorists, Baron de Montex and John Locke. We've seen how the concept has been applied in the UK in Blackburn and Attorney General. We've seen how it's been applied in the US in the Steel Seizure case. We came to Ghana, we saw how it's been applied in Ghana in Tufor and Attorney General, again in Ghana Bar Association and Attorney General. We've also seen how in MPP and AG, 31st December case, we rather affirm the supremacy of the Constitution. If affirming the supremacy would even violate separation of powers, we'll still go ahead and affirm the supremacy of the Constitution. We've also seen how in Asari and Attorney General we're told that the court will be ready to violate that concept of separation of powers if its violation rather yield to conformity with the Constitution. And we've seen our constitutional provisions that have told us how in Ghana we don't practice the strict form of separation of powers, but we rather practice the flexible aspect that comes with checks and balances, one organ serving as a check on the other. This is the end of our lecture on separation of powers and its applicability in Ghana. Thank you.